Well, after having heard this excellent presentation, it's now time to focus on the Greek paradigm. Just a parenthesis. D'autres vies que la mienne. I could never imagine that such a title could have a relation with law. It sounds more, as a drama or something like that. Well, first of all, I would like to give you a snapshot of the mission and general objective of the training courses at the National School of the Judiciary. Okay. Now, the National School of the Judiciary, it's the only national training institution for the judiciary in Greece. It's a unique one. In particular, the purpose of the mission is to select and provide theoretical and practical training on those to be appointed as a prosecutor or to those to be appointed as judges to the Council of State, the audit court, the civil and criminal courts, and the administrative courts, and to provide ongoing, continuous law training to in-service judges. Now, the training programs at the school aims at achieving 4 main objectives regarding the training of future judges. These objectives are the development of trainees' judgment in the interpretation of the rules of law, but also the factual elaboration of judicial cases, the familiarization of trainees with case handling techniques at all stages of court proceedings, the development of their capacity to formulate well-structured judicial reasoning concerning both the major and the minor premise of the judicial syllogism, and finally, the transmission of principles and values related to the ethics of the judicial function. Now, let's talk about very briefly about EU law training. The school provides training on both general and specific subject matter on EU law during the initial training phase of future trainee judges, specifically in the context of particular areas of administrative law. The trainees delve into the corresponding substantive material of EU law. That is the case, for example, with asylum and refugee law, tax law, competition law, state aid law, data protection law, etc. Now, the continuous training of acting judges, in-service judges, concerns deepening their knowledge into specific areas of EU law, as I have already mentioned, asylum and refugee law, and so on. But also in crucial topics of the general subject matter of EU law, such as the interpretation and application of EU's Charter of Fundamental Rights, to keep them constantly updated about the jurisprudential evolution. Now, the training in the general subject matter of EU law covers topics necessary for a meaningful understanding of how this law is structured and interacts within the national and international legal order. However, the relevant training presents certain particularities concerning the needs of the trainees and the objectives of the educational process. For this reason, particular educational strategies and assessment procedures are put in place that I will analyze below. Now, I would like now to focus on the initial training in EU law and the reasons why the training of EU law presents important particularities, and to state what this particularity exactly does it consist of. What is the main particularity? Dear Marie told us that it seems to the trainees that it's very technical. It has technicality. Why that? It's not, of course. It's what I call the fivefold ignorance on the part of the trainees, or it might sound very strict to you and very severe. Let's take it milder, imperfect knowledge. I equate ignorance to imperfect knowledge. So there's a fivefold, in my mind, in my experience, ignorance of the economic and political project of the EU. What is about European Union? That is why EU law seems to be a little bit technical. Always, whether it is always economy and politics stands before law. Okay? Now, then is the ignorance of the extent and scope of EU law. Ignorance of the principles of cooperation of EU law with national legal orders. Direct effect principle, primacy principle, etc. Ignorance or imperfect knowledge, if you would like, of the frequency and application of EU law in the daily judicial life. And finally, ignorance of the obligation and duties undertaken by the national judge acting in its dual capacity as a judge of EU law. Now, what are the main training objectives? Of course, first of all, it's to turning the fivefold ignorance to the extent possible to knowledge. Training in EU law at the initial training stage of future judges is intended to operate at two levels simultaneously. The first level concerns the judicial mentality towards EU law. Trainees need to understand, future judges need to understand that EU law is not just another exotic area of law, but an entire legal order, distinct but at the same time integrated into member states' legal order. It has penetrated almost every area of national law, so dealing with it, it's not a sophisticated activity, but a judicial necessity. At the end of EU law training, trainees must completely understand that they will be performing their judicial duties in a dual capacity, as I have already said, throughout their careers. In addition to judges of national law, they will also serve as judges of EU law, as provided for in Article 19 of the Treaty of the European Union, which induces specific tasks and obligations. At a second level, training aims to achieve specific learning objectives. The main objectives are to acquire trainees, to acquaint trainees with topics, concepts, and methodological tools to apply EU law in the national legal order, and to convey to them the necessary theoretical, jurisprudential, and practical knowledge of understanding how the Union's judicial system works and how the national judges cooperate with the judges of the Court of Justice of the European Union. Now, let's see a little bit. Let's talk about the key parameters of training. The training methods, which I will refer to below, defined and delimited by three key parameters. Firstly, the number of trainees. Each class in our school consists of approximately 20 to about 25 students. Each year, 2 or 3 classes are formed. The teaching hours dedicated by the school's program amount roughly to 50, for the initial stage and the general subject matter of EU law, amount roughly to 50 hours divided in 10 days, 5 hours per day. Now, as to the trainees' level of knowledge, most of the trainees update the knowledge they acquired at the university on the occasion of the entrance exams for entering the school. In general, my experience has shown that most trainees have a moderate understanding of basic concepts and topics of EU law. Now, let's have a look at the content of the training courses. Now, The objectives that I have mentioned define the blend of the courses at the initial training stage. In particular, the training program covers the following topics: the principles of cooperation, direct effect, primacy, and the nature of European Union's legal order, the internal market, of course, the economic project, the first economic project, the core of the economic project of the European Union, the architecture of the Union's single judicial system, the unified judicial system, of course, the preliminary ruling procedure, the remedies and procedures for enforcing EU law before national courts, interpretation and application of the Charter of Fundamental Rights of EU and its relationship with other systems for the protection of fundamental rights, of the system of European Convention of Human Rights, national constitutions. And this core program is constantly enriched with topics in the limelight, such as the rule of law crisis, data protection law, etc. Now a few words about the training phases. We have two main phases. We have the pre-training phase and we have the training phase per se. Now, as for the pre-training phase, refers to the activities and preparatory work before the actual conduct of training. In this case, in this phase, students are informed about the topics that will be taught, so to have enough time to update their knowledge. They're also informed about their involvement and participation in the educational process. An electronic file escorts each topic containing the critical case law and selected articles. Therefore, before even starting the training, the trainees will be disposing of all the educational material for the entire training program. Now, let's take a look at the basic learning and teaching techniques used in the training process in the school and the school. I'm referring to the use of the interleaving and blocking learning and teaching technique. Now, the interleaving technique, sometimes referred as a mixed practice or varied practice, is a learning and teaching technique that involves mixing together different topics or forms of practice in order to facilitate learning. Interleaving is contrasted with the traditional blocking learning and teaching technique, which involves studying one topic very thoroughly before moving to another topic. Now, cognitive psychologists are providing compelling and empirically well-supported arguments that interleaving is, of course, far, far more effective than blocked practice for developing the skills of categorization, problem solving, since it improves the brain's ability to differentiate or discriminate between concepts and strengthens memory associations. However, blocking technique is, of course, a prerequisite for successfully applying the interleaving technique. As every training institution, every training judicial institution should incorporate both and strike a fair balance between them in the educational process. Both techniques are used throughout the training in EU law at the school. In particular, the blocking learning technique is used mainly during the first training cycle and followed by the interleaving technique in the second training cycle. Now, let's now focus on the key training strategy. The key training strategy in our school is learning through participation in teaching. The participatory learning approach takes center stage in the educational program. None of the trainees is allowed to be left out. The trainees themselves contribute to the learning process individually or in small groups. They rotate in the roles of trainer and trainee. Thus, an environment of educational collectivity emerges rather than hierarchically structured educational environment. The role of the trainer creates, I will go in depth in a while, creates in each trainee a sense of responsibility and the need to study and deepen their knowledge about the topic they will present and possibly be called upon to answer questions from their colleagues during the course. Adults mobilize their skills when they recognize situations of necessity. In addition, in this way, the trainees acting as trainers become familiar with exposure. This is a key parameter in judicial life, the exposure to the public, whether presenting a judge, whether presenting judges, whether presenting the assigned case in the courtroom, in front of the parties, or during the deliberation process, in front of their colleagues, must speak with ease and legal completeness and express their legal reasoning thoroughly. Now, let's go back to the training phase per se. Now, the training program includes 2 training cycles, our training program. In the first cycle, the selected topics related, I have already mentioned them, to EU law are analyzed separately and evolutionarily in their historical perspective. It is about a fundamental educational decision. Trainees need to comprehend that European integration process is a multidimensional endeavor, not only legal, but equally political and economic, evolving over time and constantly interacting with history. To delve deeper in each topic, trainees should understand the necessities and questions that constantly arise in the European integration process, creating new case law challenges and answers. Of course, the training courses cannot exhaustively cover the whole jurisprudential evolution in its topic. However, the critical jurisprudential moments are highlighted. The second training cycle is dedicated to practicing through hypothetical case studies. Each internship aims to apply the knowledge acquired during the first cycle and combine material from more topics. For example, a case study may or should combine the concepts of direct effect and primacy and the topics of the internal market, the Charter of Fundamental Rights, simultaneously, etc. Now, let's take a closer look at the first training cycle. Each training cycle, these are 2 Greek words, of course, the gnosis. The cycle 1 is dedicated to gnosis. Do you know what means gnosis? Knowledge. And the cycle, praxis, okay? Now, the first training cycle. Each topic starts with a short theoretical introduction by the professor itself, who explains the basic concepts, the correct terminology to be used, this is very crucial, terminology, and points out the critical rules of EU law. Then the trainees themselves take the floor, presenting the evolution of the case law. In particular, the professor first asks how a hypothetical situation or legal issue should be addressed. For example, relating to the preliminary ruling procedure topic, the professor asks, is it legally possible that national courts may order the suspension or of enforcement of a national administrative measure based on EU law regulation, given the doubts which they may have as to the validity of that regulation? Or does Article 267 of the Treaty of the Functioning of the European Union could be interpreted as meaning that a national court may, of its own motion, refer a question to the Court of Justice for a preliminary ruling, although a national rule obliges to resolve the dispute by following the legal opinion of a higher court? Then the assigned trainee presents the jurisprudential answers from the case law of the Court of Justice of the European Union. In particular, it states the facts of its case and the critical legal consideration of the courts ex cathedra, that is, orally and without notes, without reproducing verbatim, is invited to present freely the essential key points of the Court of Justice judicial reasoning. Now, the renowned, you all know, you should know, the famous poet Konstantinos Kavafis. Have you ever heard of him? The poem Ithaka? Okay. Huh? Yes. Okay. The renowned poet Konstantinos Kavafis once wrote that the ability of description goes three stages. What should be said, what should be omitted, and where should be paid attention to. This principle works, of course, in our daily life also. Particular emphasis is placed on recounting its case facts and legal issues in a concise yet understandable manner using the aforementioned Kavafian descriptive technique. Trainees should practice this description technique. It will be a valuable asset throughout their legal careers and beyond. This method, in my mind, an exemplary way of thinking and analyzing, runs through the entire educational process. Trainees must apply it faithfully, either when presenting a court decision, processing a case file, or considering a legal solution. Therefore, every trainee, as I've mentioned, actively participates in the educational process in this phase. At the same time, the trainees themselves are encouraged to answer possible questions of their peers. The professor intervenes, the trainer intervenes to summarize, clarify, or give vital information, offers space for the trainees to operate with confidence and genuine educational curiosity. The training climate should correspond to that of a workshop or of an orchestra where each musician periodically practices the conductor's role. Now, the second training cycle. This cycle is dedicated to practicing. The training form working groups. The trainees form working groups and practice solving hypothetical fictional case studies, deepening the topics taught during the first cycle. Usually 2 or 3 working groups are formed per class. Each group is provided with the necessary case law material and articles in advance, while critical provisions of EU law are highlighted. Then each working group must proceed solving the case, presented by the professor, the trainer, during the training session, in the shortest possible time. In particular, the trainees in the working groups are invited, first, to identify and clarify the critical, factual, and legal issues. This is the first step. Second step, to structure the skeleton, the core of a draft ruling. Third step, to resolve the critical issues in a methodologically sound manner. It is pointed out that the other trainees from other working groups are intervened during the internship and ask questions. Finally, each working group should prepare and deliver a draft ruling in due course after 1 or 2 weeks. The team's grade will be factored in the final grade of the trainers. That kind of internship is an effective way for the trainers to develop their research and writing skills and to become part of the collective judicial decision-making process. Now, another topic that is very important, is very critical. Forming a fictional case study is a necessary part of the future judge's internship. The trainer must be significantly careful elaborating such cases, following, in my mind, specific standards. Essential features of these standards are what I call the transcription technique and the unfolding technique. Now, the transcription technique, the scenario of each case, this is a psychological technique. The scenario of each case is usually based on a specific or a combination of courts of justice of European Union rulings, judgments. However, having moved far away from their university studies, adults subconsciously seek a practical reason, a stimulus to devote energy and attention to anything new they learn. For this reason, the relevant facts and legal issues are transcribed in the national context. They should appear as if they had arisen in the context of a national dispute nearby to what will be trainees' future daily judicial activity. It is about a psychological trick that intends to transcribe the nationality of a case arising, let's say, originally in France, Spain, or elsewhere, thus attracting trainees' attention to the fact that such incidents occur in their own legal order. Now, the unfolding technique is a necessary medium for applying the interliving learning and teaching technique that I have already mentioned. Practicing in fictional case studies needs to unfold multiple EU law topics. For example, a case related to a legal dispute arising in the context of the freedom to provide services under Article 56 of the Treaty on the Function of the European Union can be factually structured, multifaceted, so as to require simultaneous application and analysis of rules from several areas of European law as well as principles of European Union law. Each case study must give birth to a new normal in the minds of the trainees, namely that an EU law type of case could arise at any moment of their judicial life. Now, this is a description of norm theory for which the Nobel-awarded cognitive psychologist Daniel Kahneman talks about in his book Thinking Fast and Slow. Usually our conscious or unconscious belief that something is unlikely to happen is overturned when an incident occurs, making us see yesterday's improbable as normal. I will refer to that in a while. Now, let's now focus on the trainee's performance assessment. The evaluation the assessment procedure must be integrated, in my mind, in the educational process and contribute to learning. Instead of feeling graded, trainees should experience the assessment as part of their learning experience and as an opportunity to practice what they were taught. For this reason, they are not treated as trainees, they become the trainers themselves. In particular, each trainee is called upon to choose between two alternative assessment options. Firstly, either each trainee can plan out, can design a fictional case study, which must combine issues raised in the EU law topics taught. They are only asked to design the fictional case study, in a paper or in one paper, and not to solve the case. Okay? Secondly, they can alternatively form a multiple choice questionnaire. In this version, the questionnaire should be structured so as to cover the whole range of the topics taught, and the questionnaire should contain 15 questions with 3 alternative answers per question, one of which is only the correct or the incorrect one. The rating, scales from 1 to 15, depends on the quality, ingenuity, complexity, and range of EU law topics covered. Then the trainees will be presenting their questionnaires or case law at the final training session. The answers ought to be given only by the professor himself and their peers. So as you see, the trainer himself is tested. Over the years, I have witnessed that the ingenuity and intelligence employed by the trainees in designing the questionnaires or case studies are beyond imagination. It often surprises even themselves. Some of the questionnaires or case studies present a degree of difficulty and complexity that sometimes tests the limits of even the professor himself, the trainer. It is perhaps the most, in my mind, the most fun and creative part of the training process. And there is no greater reward for a teacher than to see his students excel after a relatively short learning training journey. Now, reaching towards the end of my presentation, I would like to repeat in conclusion that training future or newly appointed judges in EU law presents particularities, and its thorough and innovative planning. The AGTN handbook on judicial training methodology in Europe offers and describes a variety of methods for designing and delivering functioning training programs to future newly appointed or in-service judges. Each national training institution should elaborate its distinct training modus operandi, sharing experiences and practices with other national judicial training institutions or judicial networks. However, judicial training institutions share the same objective, in my view, in delivering EU law training. National judges, fully aware of their status as European judges, should be trained to be EU law oriented in order to identify and resolve EU law issues originating in their day-to-day judicial activity. They must not have to search around blindly for a solution based on EU law. They must be able to find it. In my mind, an exemplary EU law training must be able to generate what I called the new normal impact. Training future or newly appointed national judges in EU law is all about creating an environment of memorable and vivid EU law incidents that's modifying the established mindset that such incidents are very probable to happen in the realm of the daily judicial life. Thank you very much for listening.